All right, friends, then keep your spirit high because now we are heading towards some of the landmark judgments on liquidated damages vis-a-vis government contracts. Incorporation of liquidated damages in government contracts is by the way of 4 feature clauses. Proof of actual loss or damages sine qua non, prerequisite. If you submit the proof of loss, we'll give you liquidated damages is something which Supreme Court follows. This is the mantra followed by Supreme Court. So let us look at our first case, Mola Bucks versus Union of India. I'll give you the brief facts of this case. Mola Bucks entered into a contract with the Government of India in February 1947. So he was supposed to supply potatoes at military headquarters UP. So Mola Bucks deposited rupees 10,000 as security for due performance of contract. Now again in March 1947, he entered into another contract with Government of India where he was supposed to supply poultry eggs and fishes at the military headquarters UP. Again he deposited rupees 8,500 as security for due performance of contract. So 18,500 rupees in total were deposited by Mola Bucks as security for due performance. However, he failed to supply potatoes, poultry eggs and fishes at the military headquarters UP, which is why government had to rescind both the contracts. First contract was rescinded in November 1947 and the other contract was rescinded in December 1947. And ultimately government forfeited the deposited money. 18,500 was the deposited money that was forfeited by government. Mola Bucks filed a case against Government of India. And the major issue was whether the amount given up by Government of India comes under actual damage or loss. Supreme Court gave a very interesting judgment. It held Mola Bucks guilty of breach of contract. Of course, there was a breach of contract. Considerable inconvenience was caused to Government of India because Mola Bucks failed to supply food items and there was a time of emergency. Of course, it was 1947. So reasonable amount of inconvenience was caused in this case. However, Supreme Court had a different explanation. Supreme Court said, where is the proof of actual loss or damage? Can government submit the proof or evidence of actual loss and damage? If yes, we are ready to provide liquidated damages. Otherwise, we cannot provide liquidated damages. Government of India failed to provide the proof of actual loss or damage, which is why liquidated damages were not provided in this case. I told you, proof of loss is extremely essential if you are claiming liquidated damages. Precisely something that was followed by Supreme Court of India. Now the another question which is constantly barging minds of courts and arbitrators is whether the amount of liquidated damages provided under the contract be reduced proportionately depending on the quantum of work till the date of occurrence of breach. You know, if you look at it from a layman perspective, definitely it is true. You know, wherever it is possible to prove the actual damages, the parties claiming liquidated damages will have to prove the losses actually suffered by it and confine its claim only to that limit and not the full amount of agreed liquidated damages However, it would not be correct to state that the provisions of liquidated damages would itself get proportionately reduced depending upon the quantum of performance achieved till the date of breach. Because if such is the case, then you will have to rewrite the entire contract. And rewriting the contract, which has already been stipulated, is not allowed under the Indian law. If the contract is formed, you cannot rewrite that contract. That is not allowed. And even more, this concept goes contrary to the basic idea of providing liquidated damages. If you want damages only for the amount of loss that you have incurred, then you can go for ordinary damages. What is the purpose behind providing liquidated damages? There are multiple damages that are provided, and every damage has its own essence. It has its own significance, which cannot be waived off, which should not be violated. So the Supreme Court has said that no matter what, whatever pre-estimated damage has been jotted down in your contract will be awarded in case of breach of contract to the aggrieved party. So we have understood two major things. One is you have to stick to the liquidated damage clause that is provided in your contract. And other is if you want to claim liquidated damages, you have to present the proof of actual loss and damage or evidence of actual loss and damage. Now let us understand whether time is the essence of liquidated damages or not. Can it change the mindset of Supreme Court in awarding liquidated damages? Let's take a look at it. So before we head towards Oil and Natural Gas Corporation Limited versus Saw Pipes Limited, let me share a contemporary issue that was raised in the court of law. We have discussed about how liquidated damages are granted in case of delay and termination of contract. But a very interesting issue was raised in 2021 that whether liquidated damages be granted in the circumstances where a contract has been terminated by the person who is claiming for liquidated damages. Let me give you an example. Say there are two parties A and B. They have entered into a contract where B has basically awarded a contract of construction of shopping mall to A. Now imagine if the construction is substantially delayed by A, is there a fair chance that B might terminate the contract? Yes, no? Let's go with yes. So if B terminates the contract, can B have a valid claim for liquidated damages despite the fact that B has terminated the contract? Now see, in such situations, there are usually three possibilities. The first is liquidated damages will not be granted at all. The second possibility is liquidated damages are available for the delay during the period before termination of contract and not after the termination of contract. And the third possibility is liquidated damages are available both for the period before and after the termination of contract. So these are the usual three possibilities. Now court was also in dilemma. It didn't know what to do, how to award damages, how to calculate. So they thought of referring to the United Kingdom judgments. There are two landmark judgments. One is Triple Point and the other is PBS Enargo. Courts have laid down two important things in these two judgments. these two judgments. The first point is language of liquidated damages clause is extremely important. Courts said it is very, very crucial to understand what has been written in liquidated damages clause to ascertain whether liquidated damages can be awarded to the aggrieved party or not. Courts usually emphasize a lot on language because legal profession itself is about language. It's about punctuation marks. So language is very crucial. And from language it can be extracted that whether liquidated damages clauses require the completion of contract or not. Because usually, liquidated damages are unlikely to be awarded whenever there is a delay. So, whether the liquidated damages clause is demanding for the completion of contract or not. Now, again, it is dependent on the language. So, basically, it's about the words that are mentioned in the clauses, the punctuation marks that are used in the clauses, and after that, it can be ascertained whether liquidated damages are to be awarded or not. It's good. We can see the progression because now courts have started passing their judgments on the basis of facts and circumstances of the case. They are not following any traditional method that has been laid down. They are emphasizing a lot on the facts and language that has been penned down in that particular clause. Having said that, let us move towards ONGC versus Saw Pipes Limited. I'm sure in this case you will be able to witness an unforeseen change, unforeseen shift, I would say. And I am absolutely sure that you may stimulate rethinking in the manner of operation of liquidated damages clauses in most of the contracts. So before we head towards the judgment of Supreme Court, let us quickly understand the facts of this case. ONGC had basically floated tender for purchase of aggregate quantity of 3,93,297 meters of seaming steel pipes. On completion of tender process, 4 purchase orders for varying quantities aggregating to 3,93,297 meters was issued in the favor of Saw Pipes Limited. In terms of the purchase order, delivery was to commence within 16 weeks and was to be completed in 40 weeks or earlier from the date of the purchase order. This is very, very important. Please note down. It had to commence within 16 weeks and had to be completed in 40 weeks. Now, there was a very important clause. I would say there were 2 important clauses in the contract between ONGC and Saw Pipes Limited. And the best part is, these clauses were applicable to all the 4 purchase orders which were issued in the name of Saw Pipes Limited. Now in clause number 9 also there were 2 subclauses. Please listen to it carefully. Clause 9A typically states that the date and time of delivery is the essence of the supply and delivery must be completed not later than the date stipulated or specified. So it was clearly laid down in clause 9A that date and time of delivery is of utmost importance. It is the essence. Clause 9B stated that even when extension in the delivery period is granted, such acceptance of extension would not mean that the purchaser cannot claim liquidated damages. Say if ONGC is granting extension of the delivery period, that does not mean that ONGC cannot claim for liquidated damages. It is possible only and only if ONGC decides to waive off the liquidated damages clause. It is the discretion of ONGC. So, in a very intelligent way, this contract was drafted. These two clauses are very important. On one hand, they are saying that date and time is the essence, but on the other hand, they are also saying that, see, we have authority to grant extension, but it does not mean that you will not face the repercussions. You will have to face the repercussions, and repercussion is nothing but liquidated damages. Now, this matter was taken to the arbitral tribunal. Arbitral tribunal said, in our opinion, time is not the essence. Why is it not the essence? Because clause 9b में तो तुमने लिखा है extension दोगे. If you have clearly mentioned that extension can be granted, तो time is not the essence. And if time is not the essence, there is no breach of contract. If there is no breach of contract, no liquidated damages can be awarded. So arbitral tribunal held the judgment against ONGC and stated we cannot provide liquidated damages. Appeal was made to the High Court. High Court had a different view altogether, and it was quite surprising because High Court held its judgment in the favor of ONGC and stated that ONGC did not prove the loss or damage suffered. So it stated that ONGC was not required to prove the losses suffered before recovering the damages. ये जो mandate था, which was an essential for claiming damages, that you have to provide the proof of actual loss or damage, was completely waived off by High Court. The matter then went to the Supreme Court, and I would like to state the obiter dicta from the Supreme Court judgment. Supreme Court actually upheld the judgment of High Court and stated that proof of actual loss or damage is not required at all. It suggested that courts should read section 73 and 74 of the Indian Contract Act 1872 together, because if it is read together, it will give you a clear idea that whenever there is a breach of contract, the aggrieved party or the plaintiff is not required to prove the actual loss or damage. He or she is not required to submit the evidence of actual loss or damage. What an interesting shift. If you look at Maula Buck's judgment, Supreme Court said we agree that there is a breach of contract because he failed to supply potatoes and eggs and fishes. But where is the proof? Supreme Court asks the government of India. Where is the proof of actual loss or damage? Those were unprecedented times, 1947. In those times also Supreme Court was asking for the proof. In Gale India Limited case, where it was clearly stated that time is the essence, but Supreme Court said where is the proof? So in both the cases, Supreme Court had demanded evidence. But in this court, all of a sudden, Supreme Court had stated that nahi, evidence ka zarurat nahi hai. If there is a breach of contract, we will provide you liquidated damages. Friends, there is one more judgment It's the recent one from 2015. I think it's very important to interpret that judgment and understand the opinion of Supreme Court. Has Supreme Court been on the same pace? Has it gone up? Has it gone down? Let's check it out. So let us head towards the last case of this presentation. This is Kailash Nath Associates versus Delhi Development Authority, judgment from 2015. In this case, Kailash Nath was declared as a successful bidder by Delhi Development Authority in one of the auction proceedings that was undertaken for plot number 2, Bikhaji Kama Place, District Centre, New Delhi. After the proceedings were finished, Kailash Nath Associates deposited 25% of money as the earnest money. After some time, Delhi Development Authority changed its mind, and without sending a prior notice to Kailash Nath Associates that they have to pay 75% of the remaining money within a stipulated period of time, cancelled the allotment of Kailash Nath Associates and forfeited 25% of the earnest money. Now, Supreme Court in this case had held, like Section 73 and 75 of the Indian Contract Act 1860, compensation is awarded for the breach of contract under Section 74 only when damage or loss is caused under that breach. Again, Indian Oil Corporation Limited judgment is brought into this frame. Supreme Court laid down that damage or loss is sine qua non, very, very essential for the applicability of damages. So, if you look at the exact interpretation that was laid down by Supreme Court in this particular case, you will come up with 4 to 5 different points that were jotted down by Supreme Court of India. It says that a party is entitled to nothing beyond a reasonable compensation under the liquidated damages clauses, and the stipulated amount is merely the upper limit that can be awarded. Supreme Court was very firm that we will not provide anything beyond reasonable compensation. So they were not in favor of unjust enrichment. Second point that Supreme Court had laid down is liquidated damages can be covered only in the cases where actual loss has been incurred or suffered and not otherwise. So the law is basically guarding both the punishment and profit as the motivations for liquidated damages. The third point that the court said, that in ordinary cases the claimant has to prove such kind of losses through evidence. In the previous judgment also, Maula Bucks, it was held that evidence is essential. It is only in rare and exceptional circumstances when there is a lot of difficulty or where there is an absolute impossibility to prove the damages. We were talking about construction contracts, construction of bridge, where it is extremely difficult or almost impossible to prove the damages. In such cases, if there is no evidence, that is not an issue. But otherwise, evidence has to be provided no matter what. And the last point that Supreme Court had laid down was reasonable compensation has to be determined as per the settled contract law. What is the settled contract law? Principles that are enshrined in Section 73 has to be taken into consideration. So here also Supreme Court said that Section 73 and 74 are to be taken into consideration together. Friends, if you look at Malaysian law, they are also following what India has been following till now. I did mention about the Cavendish approach. What did the Cavendish approach talk about? It simply talked about the reasonable compensation within the meaning of Section 74 of the Indian Contract Act. And they also believe that it is very, very essential because unjust enrichment just cannot be given to any of the aggrieved party or a plaintiff. So I think if you look at Malaysian law and Indian law, they are quite in consonance with each other. Moving forward, I would like to show a table which will give you a brief idea as to what was held in all of these cases. So here we have Mola Buck's case, we have Saw Pipes case, and we have Kailash Nath case. Here you can see the options, whether the party who is required to pay liquidated damages under the contract has breached the contract. Yes. In all the three cases, it was held by the Supreme Court of India that we are absolutely agreeing that there is a breach of contract. We are not denying the fact. All right. The second question is whether the nature of the breach is such that the party aggrieved can prove actual loss. Was it possible for the parties? So if you talk about Mola Buck's case, Supreme Court stated yes, it was possible for parties to show the actual loss. Somehow that was not submitted. In Saw Pipes case, Supreme Court stated that it is absolutely impossible in such construction contracts to prove the actual loss and therefore proof of loss should not be made mandatory. And again in Kailash Nath case, it was held that yes, it is possible and it has to be proved by the government. The third question is whether the aggrieved party has proved the actual loss or not. So in all the three judgments, the actual loss was not proved by the parties, neither in Mola Bucks, nor in Saw Pipes, nor in Kailash Nath case. And the last question is whether the court had awarded liquidated damages or not. In Mola Bucks, though there was a breach of contract, but since the liquidated damages proof was not awarded, liquidated damages were not awarded. Again in Saw Pipes, the proof was not given, but court said no, there is no requirement of proof and therefore liquidated damages were provided. But in Kailash Nath case again, the proof was not given and so liquidated damages were also not awarded to the parties. So I'm sure even if you have not understand the case laws and if you find some sort of complexity on this in those case laws, I'm sure this table will give you a brief overview of what was held in Supreme Court. Friends, we have not discussed about Fateh Chand case, but again the situation of this case is very, very similar to what was laid down in Mola Bucks and Kailash Nath case. Now that we have gone through all the four judgments of Supreme Court, let us understand the legal position of liquidated damages in terms of interpretation of Section 74 of the Indian Contract Act. This interpretation is done by the Supreme Court of India. So the legal position can be summarized as the Indian legislature has enacted a uniform principle applicable to all the stipulations naming the amount to be paid in case of breach of contract. Section 74 deals with measure of damages only in two major situations. The first is where the contract names a sum to be paid in case of breach of contract, and second is where the contract contains any other stipulation by the way of penalty. But in both the cases, one thing is for sure that it has to be a reasonable compensation. If it is not reasonable, it will not be allowed by the courts. Usually, jurisdiction of courts is limited. They have no right to interfere in between if the liquidated damages clause or penalty clauses are already mentioned in the contract. However, if the Supreme Court feels that it is not reasonable and that it has led to unjust enrichment of the aggrieved party, Supreme Court definitely has a right to pitch in. So basically that ceiling limit has to be followed. Otherwise, Supreme Court has a right to interfere. Supreme Court has clearly laid down, as mentioned under section 74, that it is a duty not to enforce penalty clause but only to award reasonable compensation. It falls under the duty. So in all the situations, in all the cases where there is a stipulation in the nature of penalty for forfeiture of an amount deposited pursuant to the terms of contract which expressly provides for forfeiture, the court has jurisdiction to award such sum as it considers reasonable. It should not exceed the amount of reasonable compensation. That court has to decide. Another thing that we have noticed in ONGC case is section 73 and 74 has to be read together. Supreme Court had clearly laid down that damages will be awarded if there is a breach of contract, if the damage has incurred and there is no need for the aggrieved party to provide a proof of loss. This was laid down only in ONGC cases. This is nothing but the interpretations that we have received so far so that we can understand the actual position of liquidated damages in current scenario. So we are just jotting down the interpretations that we have received in all these case laws. All right. So moving further, reasonable compensation will be fixed on the well-known principles that are applicable to law of contract. And it has to be in consonance with section 73 of the Indian Contract Act. The most important thing that we have understood and that we have extracted from the interpretation is whenever there is a breach of contract, the party who commits the breach does not have an instant pecuniary obligation, nor does the party who has suffered the breach becomes entitled to damages or compensation or any sort of debt that he is supposed to receive from the other party. The only right which the party aggrieved by the breach of contract has is to sue for damages. So before asking for compensation or damages, it is very much important that the party files a suit for damages and after that decision has to be taken. It cannot be taken in a very haphazard manner. Friends, the primary thing that we have learned is section 74 of the Indian Contract Act awards reasonable compensation for the loss or damage incurred by the breach of contract. Loss or damage incurred. It clearly states that loss or damage is sine qua non for applicability of section 74 of the Indian Contract Act. The plaintiffs, the aggrieved party, have to prove the actual loss or damage suffered by them. Certain words of section 74 states whether or not actual loss or damage is proved to have been incurred or caused thereby. This statement should not mislead us. It should not mislead us thinking that actual loss is not necessary. ऐसे ही liquidated damages can be provided. The above referred words in section 74 are limited to those cases where it is very difficult or almost impossible to prove the monetary loss that has been incurred by the party. So if the party is in a position to prove the monetary loss, it is extremely important to prove the actual loss or damage that has been incurred. Friends, in certain contracts, there are certain situations or certain contracts where it is almost impossible for the courts to assess the compensation arising out of breach. And if the compensation contemplated is not by the way of penalty or if it is unreasonable, the courts can award The same if it is a genuine pre-estimate by the parties as a measure of reasonable compensation. It clearly means that at times courts might think that the penalty or whatever is written in the contract is unreasonable, it is fairly high, and this should not be given to the aggrieved party. And at the same time, when it is getting very difficult for the courts to actually assess the amount of compensation that needs to be given, then courts should award that penalty even if it feels that it is unreasonable because it has been decided between the parties. It is a genuine pre-estimate that whenever there is a breach, this amount should be given as reasonable compensation, and courts will have to follow that. It is extremely important for the courts to understand that terms of contract have to be taken into consideration for determining the award of compensation that is to be given to the parties. Whatever is written down in the clauses, whatever is written down in subclauses, terms of the contract, that has to be taken into consideration. So these are the certain outcomes or maybe learnings that we have got from the interpretation of Section 74 of the Indian Contract Act. These were certain, I would say, understanding that was applied by Supreme Court in the four major landmark judgments and even in the other judgments. So I think now we should head towards the concluding part, and let us see as to what is the position of liquidated damages right now and how can it be improved, what measures should be taken to improve the present condition of liquidated damages. So let us head towards the last segment of this presentation. I'm sure after thorough analysis of case laws, theoretical underpinnings, and comparative analysis of liquidated damages, you all also have certain thoughts, certain suggestions that needs to be incorporated for strengthened contractual enforcement. So, in my opinion, I have certain points which I would like to state. The first and the foremost is the legal position on liquidated damages needs to be shifted from common law approach to civil law approach. Right now, we are following common law approach. So, if we shift to civil law approach, there is going to be strengthened contractual enforcement, and it will save a lot of time and cost, along with providing us stability and predictability of the legal proceedings. Because, friends, at present, the way in which liquidated damages are being incorporated is manifestly unreasonable. So, to make it more reasonable, to save on a lot of time and money, we need to shift to the civil law approach. If you look at the judicial interpretation of Section 74 of the Indian Contract Act, there is a need to bring Indian position of law at par with international instruments. See, for example, unit right. Unit right does not make it mandatory for the aggrieved party to submit a proof or evidence of loss or damage for receiving liquidated damages. This is one thing that we can adapt in our Indian position, in our Indian law as well. For those who do not know what unit right is, unit right was established in the year 1926, and it is nothing but an independent intergovernmental body or organization that has its seat in Rome. So the purpose is basically to study the needs and methods for modernizing, harmonizing, and coordinating private and specially commercial laws between the states and group of states, and also to formulate a lot of uniform laws, instruments, rules, and other policies in order to attain the objectives. So this is the major task of unit right. So only thing that we need to incorporate and need to adapt in our system is to remove the mandate of submitting proof or evidence of loss and damage. There are certain words in section 74 that needs to be changed in such a way that it focuses more on genuine pre-estimated losses. It focuses more on the clauses that are already mentioned in the contract, or maybe a mandate to mention about liquidated clauses in the contract. Something like that should be added or modified in section 74 of the Indian Contract Act 1872. I would also suggest that you read Specific Relief Amendment Act 2018. So right now, if we look at the current position of liquidated damages and penalty clauses, it is extremely important that certain modifications should be made in a way that it resonates with the objectives and changes which are already brought in Specific Relief Amendment Act 2018. Now I would like to ask a very simple question to you guys. This is not a part of your examination or a part of your assignment. This is a simple question from my end, and you have to solve it. Say, for example, there is one cricketer from a country B. Let's consider the name of that cricketer as A. He is from country B and he has entered into a contract with India that wants A to play in team C. Right. So A is the name of that cricketer. He's an international cricketer. B is the country from where he belongs, and C is the team where he's going to play. It's Indian origin. All right. Now, a contract is made for a period of 3 years. They said this contract is for 3 years. We'll be paying you 5 crores for being a part of Indian Premier League. That is Team C. All right. Now, there is a contractual provision in that contract which states that in an event of unjust dismissal, please note, in the event of unjust dismissal by the team, A will be awarded compensation of rupees 25 crores. Now, within 6 months only, A was removed. There was unjust dismissal with A, and he was removed within 6 months. Contract was for 3 years. In meantime, A was hired by some another company D that offered 10 crore rupees to A. यहाँ से A का dismissal हुआ. On the other hand, A has been immediately hired by a company D. Is A liable to receive rupees 25 crores or not? Can 25 crores be awarded as compensation to A despite the fact that A has already been hired by company or team D? This is my question. I would be glad if you could answer this question. I hope the session was informative, and I hope you have understood what I was trying to convey through this session. If you have any doubts, you can always reach out to us via our official email ID. Thank you so much for being patient, and I wish nothing but the best for each one of you. So good luck with your assignments and for your exams and for everything that you're going to achieve in future. Thank you very much.